Hi, this is Michael Pariente of the Pariente Law Firm PC here at the Howard Hughes Center in my conference room. I'm a criminal defense lawyer here in Las Vegas, and I've been practicing law for well over 17 years now. Today I'd like to talk about what went terribly wrong for former United States Speaker of the House, Dennis Hastert. As many of you know, months back he pled guilty to one count of lying to an FBI agent and one count of structuring to evade financial reporting requirements. The FBI was investigating his involvement of paying hush money to several young men whom he had molested years ago before he ran for Congress. Now, when he went into his sentencing hearing today, he was very likely under the impression he was going to get probation. And the reason why is because the U.S. attorney and his attorneys had agreed to what is called a Federal Rule of Criminal Procedure 11C1B agreement. What that means is that the parties are agreeing that they're not going to argue for anything other than what is in the guidelines. And the guidelines they'd agreed to was, I'm going to be really technical, then I'll break it down. Category 1, offense level 4, zone A. What that means is that Mr. Hastert was looking at anywhere from 0 to 6 months, but he was probation eligible. And so if the government were to make an argument for more time than what was in the plea agreement, they would be in breach of the plea agreement. So the plea agreement prevented them from asking for any additional time. It was a binding plea agreement on the government. The problem for Mr. Hastert was this was not a plea agreement pursuant to 11C1C. If it was under 11C1C, the judge would have been bound by the plea agreement. And if the judge didn't want to go along with the plea agreement, the judge would have to allow Mr. Hastert to be given the opportunity to withdraw his plea. He would tell him, I'm not going to follow this agreement. You may withdraw your plea. I'm sure Mr. Hastert would have done so. But because it's under 11C1B, Mr. Hastert could not withdraw his plea agreement after the judge chose to sentence him to 15 months followed by 2 years of supervised release. And that's a big departure from what he was expecting. He was expecting probation, and I'm sure the U.S. attorney and Mr. Hastert's lawyers were all expecting the judge to give him probation. But that's the problem when you don't have an agreement under 11C1C, and they are very hard to get, quite frankly. I've been practicing federal criminal defense for many years, and I've represented nearly 700 people in federal cases, and I can tell you those 11C1C agreements are very difficult to procure. But in any event, that's what happened today, is the judge said, I'm not going to give you probation. I don't care what the U.S. attorney and your attorneys have agreed to. I'm going to give you 15 months of federal prison time followed by 2 years of supervised release. Supervised release is like parole. Now, if you're being charged with a federal offense or you're being investigated for one, give me a call. I'm more than happy to meet with you in person. Or if you're calling from out of state, give me a call. Let's talk over the phone about what I can do to help you.